For years, we have discussed how a genuine economic and monetary union requires establishing a fiscal center with fiscal capacity, and how only a large, genuinely European political project would shift the union from an intergovernmental logic of decision-making to a more solidary and democratic institutional framework. And the first question is it possible that coronavirus crisis is one of the events that can cause this shift? If so, this could be read as a confirmation of what Hannah Arendt wrote years ago. It is not ideas, but events that change the world, even if it is ideas that often set the change in motion. It was not the Cartesian doubt, but Galileo's telescope that practically changed the vision of physical world, making Cartesian philosophy come true. So we would like to discuss the events we are currently facing, the telescope, not only through the lens of the challenge brought by the German Constitutional Court to the European Court of Justice and the European law of supremacy, with the alluvial debate to which it gave already rise, but also through the lens of the hard economic and political choices that the European institution and the national governments have taken and are going to take. The two plans are actually intertwined. It has been noted by Daniel Sarmento and Joseph Weiler that many believe that the dramatic shift in Angela Merkel's approach, the leader I was quoting before, her approach to the crisis is due in no small part to a reaction to the Vice decision, in which can be defined as a spectacular twist of the law of unintended consequences. Before giving the floor to Antonio Lo Faro, the seminar, let me add the seminar dedicated to the memory of Lauralba Bellardi. Lauralba was a leading labor law scholar, an expert of industrial relations. She belonged to a great scholarly tradition which goes back to Gino Giugni. She was also, for many of us, a very good friend, but everyone who had the pleasure to meet her could easily and quickly realize how kind, good-humored, and clever she was, and lastly, how courageous in fighting her fight against the illness, unfortunately lost. So we will honor her with the next seminar we are organizing, a seminar which will deal with an issue that she, as well as many of us, care very much about. That is the women's work, a theme that the pandemic has put again in the foreground in old and new ways. And with this, I give the floor to Antonio. Thank you very much.
Thank you, Marzia. Let me just add a few words, starting precisely from the unusual title of the seminar, not exactly what Europe 2020 was supposed to be. This title just intend to say materialize a feeling, a sentiment, which I guess any European citizen has at the moment. Because Europe 2020 was an ambitious strategy launched in 2010 with a view to make of Europe the most dynamic and socially sustainable economy in the world, building on solid legitimacy foundation. And what we see, on the contrary, 10 years after, is a bulk of institutional problems like Brexit, political problems, growing nationalism, economic problems due to the pandemic, but not only to the pandemic, and legal problems, German Constitutional Court ruling on PSPP. So one does not really need to be a Eurosceptic to have some doubts, probably no certainties whatsoever about what is going on. So our idea with Marzia and the other friend of the international section of the labor law community, Alberto Perulli, Piraloi, Stefano Guboni, was to discuss precisely if and how all of these problems could be somehow cross-cutted by a common pattern of analysis, and how they could be relevant for labor and social law, which has always been an essential part of the economic constitution of any legal system, and the more so in European integration process. So this is not to try to predict something, but just to understand how some of the keywords of our time, proportionality, conditionality, stability, judicial dialogue, and so on, would end up in affecting social and labor law. And it is no secret that there is some worry about that. Because when talking about emergency measure, history teaches that once changes has been made, there is often no way back. What it is presented as an emergency measure then become ordinary. So that's basically what we will be discussing with a panel, which I would say is even too distinguished to be presented. But I wish, however, to present our guest. Christian Joerges, who is now Emeritus Professor of Law and Society at the Hertie School of Governance in Berlin, has extensively written on the issues of European integration theories, European economic law, economic governance of the EU, and within that, he also repeatedly took care about the tension between economic and social side of the integration. Miguel Poiares Maduro is currently professor and formerly director of the UI School of Transnational Governance, the leading scholar in constitutional and international economic law, and he is quite well known among labor lawyers because he was serving as Advocate General in the Court of Justice when the Viking case was decided. Augustin Menéndez is professor of legal theory at the Universidad Autónoma de Madrid, is fellow of the Arena Center of European Studies in Oslo. His research is an original synthesis of constitutional or legal theory, human rights doctrine. All of them refer to European integration process. He is as well a labor lawyer in a sense because he has recently written on freedom of movement. So, although our guests would not qualify themselves as labor lawyers, all of them had indeed several contacts with labor law. And this is why their individual profile testify in a way that the connection between constitutional frame of the internal market and labor law is there. Last but by no means least, we are extremely pleased to have in our debate Dr. Vito Borrelli, currently heads the Commission representation in Italy. I really want to thank Dr. Borrelli for his kind availability to be here and to play a role that we consider as crucial, because he will have the task to bring in our discussion voice of the Commission, which currently is one of the institutions called to drive the process of pandemic recovery, probably more than the ECB or EMS have done so far, the crisis. Not to say that the institution Dr. Borrelli represents would also have a role in the Karlsruhe versus Luxembourg quarrel if, I underline, if an infringement procedure will be brought against Germany, we will see. So we have prepared within this frame some questions as starting point of the speech. And we would like to pose this question to each of you. So we will have 4 rounds of 4 answers for each of the 4 questions that we have prepared. This is why I would warmly ask you to keep each of your intervention in 5 minutes. We will be disciplined enough, we will be capable to complete this round in an hour and a half, so that at the end we could have 10 minutes or 15 minutes for questions.
And Antonio, can you repeat the time, the amount of time?
Yes, 5 minutes for each answer.
Five minutes, okay.
Yes. So I would start now to question number one, and I propose this order of answer, which I will alternate afterwards. So Miguel, Augustin, Vito, Borrelli, and Christian. And the first question is, the European Union is trying to put on the table in these weeks a series of instruments, some existing instruments as the EMS, some brand new instrument as the Next Generation Program and the SURE Fund. The question is, would you say that this could be sufficient to attain a fair balance between risk sharing, debt mutualization, and at the same time allowing solidarity and improvement of EU economic and social policy? Miguel.
Okay, so I have a saying that I always use when we're talking about projects and the extent to which the European Union really meets our expectations, and what is necessary, more than perhaps better than meeting our expectations, does all that is necessary to address the challenges the Europe face. I always say that we should be prepared for the final outcome to be not as good as we would wish it to be, and not as bad as we could fear it to be. And I think this will be another example of that, but one in which so far, mostly due to the Franco-German initiative, picked up and amplified by the Commission proposal, I think we have to recognize that it tends to be more than I actually thought might be possible at this stage, if indeed it will be this kind of program that is being discussed. As some of you might know, already some months ago, I wrote some proposals in this respect with regard to what should be the answer by the European Union. I was very skeptical on the instruments that were adopted by the Council following the proposals of the Eurogroup, focusing on the ESM, and mostly because they will involve, even if they could facilitate, or it was the same thing, by the way, with the Corona bonds proposal. Any proposal that will involve basically debt being issued by states, even if jointly liable, proposal that from my point of view will be flawed from what we could expect as the outcome of the European Union answer. This is so because, as we know, even if the virus can affect equally all states, or can potentially affect equally all states, the impact on different states is very different, both as a function of how the virus spread, as a function of the reality of economic sectors. Countries whose economic sectors are more dependent on liquidity will tend to suffer more. Countries that depend on economic sectors that are strongly based on socialization, such as tourism, for example, will also be affected more. But then the other function that will determine the asymmetric impact of the virus will be the fact that states did not have the same financial muscle, because some of them would have to address this crisis being with very high levels of debt already, and so could not do that. And in my view, that meant that we could have not only an increase on divergency on the European Union, that is, increase a strong asymmetric impact leading to further divergence on the European Union, what will run against the principle of cohesion and in my point of view would justify a claim based on solidarity. But moreover, and perhaps more important, I think there was a strong argument in terms of fairness. That is the different capacity of different member states to intervene, to address the economic and social challenges brought by COVID-19 will mean that some states will be able to use the increased flexibility of EU rules, both with regard to the European semester and to state aid rules, to provide much stronger economic support to their companies than companies in other member states. And this was not an issue of solidarity. This was an issue of the integrity of the internal market and the fairness of the internal market. And that was what, in my view, would justify that the recovery plan of the European Union should go beyond simply aiding member states to finance themselves in the market, and will require a centralized program that would also have a very strong component of grants to correct, not only for reasons of solidarity, but also to correct the distorted impact in the internal market arising from the different firepower, financial firepower of the member states. And I think that was a very important point, and the point that I made from the beginning of the crisis. I thought that in the beginning there was a mistake then by some member states of claiming that this was that the reason for the European Union to intervene will be mostly one of solidarity, but one where solidarity will not involve, in this instance, a problem of moral hazard, because the virus could not be, the impact of the virus could not be attributed to wrong policies of the member states. I think that even if this was right too, there was a much stronger argument to be made in terms of central intervention by the Union with grants, not only financing, being justified to guarantee and preserve the integrity of the internal market, and not allow that the use of the flexibility of the more flexible application of EU rules, both on budget discipline and on state aids, will lead to the companies in some member states being gaining a competitive advantage with respect to companies in other member states. I think that the current proposal of the Commission reflects this. It's a smart proposal in that respect. And it reflects this in two ways. First, because it's not a joint liability issuance of debt. So it's debt issued by the European Union, but that will be guaranteed by the European Union itself on the basis of the resources of the European Union. It's a proposal that also links to the creation of new own resources, something that I've been defending for many years and did so in a report, notably in 2012. We can, in the discussion, go more into this. I won't do it now. And finally, because it is a program that has a very strong component in terms of grants. Now, crucially, in my view, would also be then how first that this program is adopted. It won't be easy because it will depend on a new decision on own resources that, as you know, requires a process of approval very similar to almost to a treaty amendment, because it requires not only unanimity in the Council, but also ratification in the different national parliaments. So that's going to be a huge step. But if indeed it is approval, I think this program goes in the right direction, and it means that the Union will, in my view, answer to this crisis in a much more satisfactory way than it did with respect to the financial crisis from 2008 and 2011.
Thank you, Miguel. Augustin, this idea that the COVID shock is not symmetric at all, contrary to what you think of it. You have written something about that, precisely saying that this is not a symmetric shock.
No, it is not at all. I think, and the reaction, the policies that have been implemented so far are not symmetric either. I think we should remind ourselves that so far the Eurozone has suspended sine die the key norms of the economic and monetary constitution, creating the legal and economic space in which each member state, acting alone, can hibernate its economy. Competition rules, in particular state aid, have been suspended. The Stability and Growth Pact has been rendered toothless, and the ECB, through the PEPP, buys debt in almost unlimited quantities, and does so in a radically new fashion because it buys asymmetrically, or what is the same, acquires more debt of the state in need of issuing more debt. As a result, Pace, Mario Draghi, Santo Subito, states may spend as if there was no tomorrow. Now we are all dirigist. Now nationalization, certainly temporarily and partial, is the policy not of the Communist Party, but seems to have become the new normal. This decision is, however, two-edged. On the one hand, the suspension has prevented the immediate collapse of the national economies and the Eurozone. On the other hand, it risks multiplying existing national and regional inequalities because not all states, as Miguel was pointing, have the financial resources and credit to intervene. Precisely because it is not true that there is no tomorrow, there is a tomorrow. And in that tomorrow, and we should keep this very clearly in our minds, the old fiscal and monetary rules will still be there. So, unless they are changed. So it is simply not true that all states can have equal resources to hibernate and reconstruct through borrowing and spending. So, the exacerbation of territorial inequalities, already a consequence of the single market and the single currency, can be pushed to new levels by the very policies deployed to govern the crisis. It's not the consequences of the crisis itself, it's a consequences of suspending the framework, which is necessary, but it has very clear effects. The major contradictions at the core of the European project are thus back with a vengeance. Unsurprisingly, political struggle has followed, on the face of it pitting North against South, but at the same time reflecting an emerging massive distributive conflict between persons and classes. So far, the initiatives taken by the Commission, including the once called Recovery Fund, now it has a different name, seem to mark the willingness to depart from the path so far trodden, but are simply, I would say, insufficient to the task which the Eurozone confronts. It is very proper to reflect to expectations, but I think it is also proper to keep in mind numbers. And numbers here, what they say is that at best, what we have is a 4% GDP stimulus over 2 to 3 years, starting sometime in 2021. And that is too little, far too late. Why is this so? If the purpose of collective action was to ensure a fair distribution of the costs of hibernating the economy and relaunching it, it would be necessary to fully transcend the logic of the present monetary and fiscal constitution of the Eurozone. What we are witnessing is the collapse of the understanding that this is something that can be stabilized in time. It cannot. We have to change the rules. In particular, it would be necessary to develop the means to ensure both intra-state distributive justice and interpersonal distributive justice. For such a purpose, it is necessary to envisage either the Europeanization or the reinforcement through the European Union, not of sin taxes, which is what is on the table, carbon tax, plastic tax, digital tax, whatever tax, but of the personal and the corporate income tax. Now that seems to be several bridges too far in political terms. The levels of interstate redistribution which are feasible, that is the Macron-Merkel initiative, are manifestly insufficient, and those that would be required are politically unfeasible.
Thank you, Augustin. So maybe Dr. Borrelli can give us some more details about this new instrument, which is based on Article 122, which is an emergency tool, however. Can you give us some detail and maybe also tell us if there is some unexpected political compromise about that or not?
Well, good afternoon, first of all, and thank you for inviting me to this very lively roundtable about the EU measures in times of coronavirus. getting back to your question, I would like to say that I think that the latest initiatives of the European Commission in response to the coronavirus emergency very well show how it is possible to reconcile monetary and economic policies and European fundamental democratic principles. I would like just to quote briefly President of the European Commission, Ursula von der Leyen, from a speech she gave only 2 days ago on the occasion of the Stati Generali, this convention that the Italian government has decided to convene to discuss and identify solutions to relaunch Italy. On that occasion, on the 13th of June, President von der Leyen said, "Solidarity is not just the most ethical choice, it is the only effective way to deal with a crisis of this magnitude." So I think the time has come to realize that solidarity is just not, it is of course a principle and altruistic attitude. It is not only that, it's only the interest of all member states to be solidar with the others in order also to get benefit themselves. And this is in fact the core idea behind the Next Generation EU. This is the name that von der Leyen wanted to give to this new recovery instrument that has been proposed by the Commission on the 27th of May. And I find this choice of name very interesting because it links to a sort of intergenerational pact with our future actors that will be in charge of leading Europe and the rest of the world. Because of course, what we are doing today is also in some way taking some money from that our next generation will have to pay back. So this is a very important and crucial and also very responsible act that we are doing now for the interest of Europe and for the interest of the whole world. If we just very quickly go through the history of Europe, we remember that the Union's founding generation worked to build a lasting peace after a terrible war. And the generation that followed in the 80s and then in the 90s, in 2000, tried to pursue prosperity and freedom, choosing the unity of a single market and a single currency. Now, the next step, the one that we are pursuing today, is much about sharing risks and benefits. As you said, it's not obvious and it's not easy because the Commission proposal will have to be endorsed and adopted by European Council, which is represented by the 27th member states. But I think that the time has come for many countries to realize that if they accept these apparently altruistic mechanism, they will have to benefit themselves from it. So we are all aware that there are some frugal countries that are not going to accept the proposal as it is. They will certainly want to introduce some conditionalities. They will want to diminish the part that concerns grants with respect to loans. But I also realized in the last couple of weeks that there's been a change of approach from these countries. Some countries, like Denmark, for instance, has become less firm on these demands. And I think that the dialogue is slowly but firmly opening in view of the next European Councils. I'm not thinking in particular to the one of next Friday, of the 19th of June, where I'm afraid that we will have still a sort of open discussion and still difficulty to find an agreement. But in July, when we'll have the next extraordinary European Council, that should be also the first physical council after months of virtual meetings, I think that we will gradually approach a solution that should be in favor and in benefit of all the countries involved. Now, to come to your last question, about details on the next generation EU. As you know, the proposal is based fundamentally to three main pillars. The first being the need to support member states in this phase of crisis to recover as much as possible from this situation. And this will be this first pillar, which includes the biggest part of the Next Generation EU, which is the Recovery and Resiliency Facility, is very much structured within the framework of the European semester. So, of course, it will be linked to the preparation of a very clear program and a program of reforms that the country has to present within possibly within the end of this year. And the other two pillars are the necessity to kickstart economy and helping private investments, and learning lessons from the past, from the crisis, in fact, with the launch of a new health program, with a reinforced RESC-EU facility, and with a reinforced financing of programs like Horizon 2020 and other programs for research, innovation, and external actions. We will see whether these big ambitions of the European Commission will be accepted by member states, but I think that the time is ripe now for countries to realize that there is interest for all to accept these.
Christian, it's up to you. You should unmute your mic.
Yeah, and we always save, and I will save time. And this is also important. 3 very brief remarks. The first one, I find the initiative really stimulating, and I was very happy to see that our Merkel is suddenly becoming a statesman type of figure. This is no longer the union method Merkel with her conditionality and this kind of stuff. This is really somebody trying to understand the European problematic. The second, however, is to Augustin. You know this famous word by Draghi, believe me, it will be enough. I would say, believe me, it will never be enough. If you ask for the money, it will never be enough. The important thing is not to raise the money. The important thing is how to spend it. We have had this experience in Germany of unification. This was a small, little, tiny country, the German Democratic Republic, 14 million at the time, 17 million people. It was bankrupt. And Germany, nearly Western Germany, had to burden this. It was an enormous burden. Solidarity was there, enormous amounts of money were flowing. The problem was how to spend the money in a way that would be constructive. And what we have experienced is that there are enormous problems. Now, I stop here because I'm simply saying this will be something which you do not find now. I've tried to understand these documents from the Commission and these wonderful wordings and so on, but the problem then to find ways to spend the money in a constructive way is still too early. Nobody knows that, but I believe that there will be the real problem of making good use of a lot of money. Basta. No, I don't hear him.
Sorry about that. So let's go now to question number 2, which in a way has the ambition to go beyond the emergency period and try to imagine which possible ways could be experimented to make a final leap out of these ambiguities that already have been dealt with and find a way to properly reconcile monetary policy, economic policy, and the democratic principle in the EU. So not only as a response to COVID-19 problems, but also for the future. So I will start with Christian again. Do you think that fiscal and distributive effect of monetary policy could survive for some time along the Gauweiler doctrine, that kind of perspective given by the court, or something more radical is to be thought about.
Yeah, this is the most intriguing element of the Maastricht Treaty, that they tried to define, or they believed, even some of them believed, enough people who didn't believe it, who said that we have to distinguish between monetary policy and economic policy and fiscal policy. And of course, all the member states have defended their money. The power of the purse was universal in Europe. Nobody was ready to grant the Commission or European institutions access to that money. What they have done was a fatal mistake, in my view. I call this a diagonal conflict, and we'll later talk about supremacy, and then I come back to it. But the point, my little point is, if you have two interdependent policy fields, monetary policy, economic policy, fiscal policy, and you have different masters, one master saying, I'm the master of economic policy, of fiscal policy, others saying, I'm the master of monetary policy, and you don't establish a mechanism how to reconcile the unavoidable conflicts between these fields, then you have created an irresolvable conflicts. And this is exactly what we have done in Europe. The non-provision of a mechanism to resolve the conflict between these fields was a fatal misconstruction of Maastricht. And it was one which cannot be resolved by law. I will come back to that also later. But the problem is that I say the Maastricht Treaty was no constitutional arrangement at all. It was the establishment of a constant bargaining and modeling through process. And it was one where you then resort instead to legal constitutional frames to power. I don't think that this way in which we have established monetary union could ever become a solid ground for a European arrangement in these difficult fields. The way out of it is a difficult one, but I'm just saying, instead of criticizing the non-obedience of this and that state with this and that rule, is to see that we have established a conflict conciliation and no political authority which would be legitimated to resolve these conflicts. This is the dilemma we are in, and I would think that we are getting out of it somehow. Okay, basta.
Thank you, Christian. I don't see Miguel anymore. Okay, Augustin. One of the possible ways which have been discussed as a way to overcome this monetary policy versus fiscal policy dilemma is for the EU to have or to increase its own resources by acting on the EU budget. Would you say that this could be a key to overcome all this kind of problem once the EU have its own budget? So any discussion about moral hazard, about the way to spend money could be overcome or not?
I think the underlying problem is the fact that we have an ersatz of a federal polity, and we have been having one for all the time. That's the reason we have a copy. We are pretending that we are something that we are not. That's the reason that, or from that come all the complications related to the distinction between the completely artificial distinction between monetary policy and economic policy. It's very interesting to notice that the disagreements, for example, between the two courts already started in 2015 with the previous round on Guy Weiler. If you read carefully, the Advocate General of the European Courts of Justice is already pointing to that. At the same time, it's impossible to get rid of the distinction because it's not only in the treaties, but from Maastricht is in the German constitution. What we have is a silly piece of constitutional law, the German and the European. Now, for very good reasons at the same time. It's a silly piece for very good reasons. But I think that what all this illustrates is that we cannot any longer muddle through crisis. To say it in Italian adapting the saying, I nodi sono già oltre il pettine. A choice has to be made between, on the one hand, further integration, which requires the union ceasing to be this strange animal that pretends to be something that is not, and become a democratic federation, and on the other hand, happy disintegration. And I would emphasize that, talking to what Christian was pointing in his comment, in a way. I was not asking for more. I was pushing the argument to the limits and showing that the argument does not work. So perhaps we should consider happy disintegration, seeking for an alternative configuration of the European project, necessarily through a monetary infrastructure alternative to economic and monetary union. For example, the proposal that Wolfgang Streeck or Friedrich Schaff have made in going back to, in one way or the other, the European monetary system too, so to say. The first road is full of dangers, not least because it's unclear not only how it would be possible to define a democratic European general will, but also because it's not obvious either if the necessary political preconditions to create a European polity are there. I think that we have had enough, more than enough, of clever in vitro constitutional engineering. We have had far too many white papers, far too many wise men, tellingly they are mostly men, and we have too many commissions and too many proposals. Where are the political parties called to be the decisive actors in this process? Nowhere. The second solution, the happy disintegration, requires a level of mutual cooperation that has been so far lacking in European politics. A revamped European monetary system would require massive coordination to move from the present arrangements to a new structure and then to govern it efficiently. At the same time, however, what has emerged with full force, and I insist and I leave it here, is that the status quo is simply impossible. You cannot have a monetary union, working monetary union, and keep on pretending all the time that one thing is monetary policy, another thing is economic policy. You cannot. And at the same time, you cannot have a democratic monetary union if you do not have a dividing line between what the European Central Bank can do and what it cannot do. So the two courts are right. The problem is that you cannot reconcile the two being right at the same time. What is wrong is the structure that we have.
Thank you, Augustin. We will be back probably on that, on the last question. Dr. Borrelli.
Yes, thank you. Well, this is a rather thorny issue. It has been such for many years. We are aware that from the start, the European Economic and Monetary Union project has been accompanied by central debates, two main central debates. The first relating to the order of integration, with some arguing that political convergence should come before monetary union and others reasoning that economic integration would spur political integration. So this has always been the vicious circle, what should start first. The second relates to the question of whether to already incorporate new members into the euro area or first deepen its institutional underpinnings. These debates highlight, in a way, choices that go beyond economic considerations. They reflect Europe's common will to grow closer together over time, and that political commitment has proven to be stronger than many believed. But if this commitment should continue, should endure, it will need to be supported by effective policies. To make clear the role of governance of the Eurozone in the architecture of the European economic and monetary union. And in the reassurance of both new and existing Euro area members, we need to collectively ensure the accession is fully prepared. I think that in more general terms, one of the next step for Europe to discuss and decide on long-term decision will be the conference on the future of Europe that will be launched under the German presidency. It should have been launched under Croatian presidency. Unfortunately, due to the coronavirus crisis, this was all postponed, but I think Germany is very well placed to give a very strong boost to this analysis that will, of course, cover a number of other topics, but also, and in particular, the economic and monetary union. Thank you.
Yes, Miguel, what do you think about this conference on the future of Europe, which you were talking about? Can you hear me?
No.
Miguel? Are you there, Miguel?
Disappeared.
You are there, but you cannot hear me.
You must unmute your microphone, Miguel.
Yeah, but I think he doesn't hear more than. Can you hear me? No. Okay, so let's keep Miguel on the screen. Maybe we can recover his intervention afterwards, and we could go on with question number 3, which is something which comes closer to a labor law and social law profile of the question. Now, we know that among the European Union economic governance rules, there are some rules which are of primary interest for labor law, such as state aid rules, stability pact, and conditionality. So state aids and stability pact have been suspended, but conditionality is still there. Even if it is said in political fora that it will be put apart. So the question is, do you think that is that possible? Do you think that conditionality could be really set apart without a treaty modification? Augustin.
The short answer is no. The long answer is slightly more nuanced. The following sense. I think, legally speaking, it's very obvious, and we have had the discussion recently regarding the so-called sanitary or health mess. No, we have very strange arguments being made. We have the argument that on the basis of Mr. Gentiloni writing a small piece of paper, we have get rid of conditionality. What we have is the political will to do so. If you want to get rid of conditionality, then you have to change the 2-pack. And you have to change Article 136.3. Because if you don't do so, then the question is that you are opening up your decision not only to an eventual different political majority in the future, but you are opening up to being challenged before national constitutional courts. I see very obviously that there is an open way in order to do that regarding the German Constitutional Court after the decision in Weiss. So legally, I think the answer is no. Politically, the question depends on changing not only the law, but also changing the political values, the political views that are dominating in the European political process. And I think conditionality has got the very bad name for good reasons. The good reasons is that it is presented as a technique, but is corresponding to a very specific ideology, a hybrid of ordoliberalism and neoliberalism put into action through the oxymoronic expansionary austerity. Now that Alesina has passed away, we can remember his paper for the ECOFIN of April 10th, 2010 in Madrid, in which he proposed this concept of expansionary austerity with the results that we all know. This devastated the economies of the southern periphery, and remains part and parcel of the imagination of economic and monetary union. Let's make no mistake. What the German and the Constitutional Court and the European Court of Justice agree is on the idea that the euro is a community of stability in the precise sense that member states must be forced to be disciplined by markets when borrowing. This is still there. It has only been suspended. If we want to transcend conditionality, we have to get rid of that. What we cannot expect is that it can be rendered harmless. And this is a legal point in which we can discuss, but we have to discuss with legal points, not with the declarations of intention of will. It cannot be rendered harmless without a formal change of the norms of the Article 336.3 and of the two-pack.
May I intervene?
Yes, thank you, Augustin. This is precisely what I was thinking about. You know, we are continually being said that conditionality is no more a problem. Also at the Commission level, and I was wondering how this could be said, because I agree with you. It's difficult to get rid of conditionality as far as it is in the treaty, but we will see. I would turn to Christian now, and then
brief intervention. I mean, the German constitutional law is not very popular these days. However, it has one very interesting doctrine, and this is the doctrine of verfassungswidrigem Verfassungsrecht, unconstitutional amendments in English. Now, unconstitutional amendments are amendments which are not in line with the commitment of your democratic constitutional state to democracy and the rule of law. And conditionality is exactly that. It is you obey, we pay. This kind of deal. And this is not the thing a democratic polity should exercise. This is my concern, and I know I'm lonely, but the doctrine is indeed accepted in principle. When you come to apply it, is of course all very different, but it is the problem that you try to arrange through command and control what cannot be accomplished through it. It is the same point I made in the beginning. It is not the point that we don't have enough money. The problem is that we cannot really command the exercise, the useful making good use of this money through some hierarchical machinery. Conditionality is one of these machineries, and the experience we have in many examples from Italy to Germany, it does not really work the way you would hope to. It doesn't work, but this is the empirical side of it. The normative side, I think, is equally serious, and I believe, okay, I will come to this when we talk about supremacy, but I believe strongly that we have to move away from conditionality through cooperation. Cooperative problem solving, I see a glimpse of that in the new readiness to join forces to come to grips with the corona crisis. But the principle is one, I would say, it needs cooperation rather than some strict type of conditionality rule which would resolve our problems. It does not. Okay. Marzia. I think the conditionality actually, it will not be exercised anymore. It is, so to speak, unfeasible.
Thank you, Christian. Is Miguel back with us?
Yes, I am. I apologize, but my Mac crashed, and at a certain moment, I was still seeing you, but I was not hearing you, and I could not do anything with the phone. And then when I came back, it was the audio that was not working. But now it appears to be working, so fingers crossed for now.
Okay, so maybe you could melt two answers to two questions. The previous one that you had not the possibility to answer was about this separation between economic policy and monetary policy, whether or not we could see some radical turning point capable of keeping us of these ambiguities of making distinction between fiscal, economic, and monetary policy. And the third question was about the possibility of putting apart conditionality. And this is precisely what the Commission and other political fora are saying, that we can use ESM and other funds, putting apart conditionality. Doubt is whether or not this can be possible without modifying the treaty. So,
okay, let me start with this last question. I don't think that they have said that they will put apart conditionality, and I don't think it's a good idea for the European Union to give money to its member states without conditionality. So I'm a bit. I only think that it needs the right kind of conditionality. And what has happened so far is that the conditionality that's been used by the European Union, imposed by the European Union, is the wrong kind of conditionality, both in terms of the incentives that it creates for member states, and both in terms of the capabilities of the European Union itself to then follow up on the conditions that imposes on member states and appropriately monitor compliance with them. So let me explain what I mean with this first. In my view, it's not true that it has been said that they're going to get rid of conditionality. That's possible to use. It's not even that. It's true for ESM that there was going to be no conditionality, as normally it is the case with European Stability Mechanism, but no fiscal conditionality. But that's because at the same time they made another kind of conditionalities, that the funds could only be used for medical expenses, for medically related expenses. So that's a form of conditionality, saying that you can come and finance yourself through the ESM, but you can only use the money for this purpose. And I think that's also one of the reasons why, in fact, no member state has expressed, to my knowledge, has expressed interest so far in having recourse to the ESM during this crisis. None of them. And I think it's related to that in fact, it's very little
Cyprus.
What is there.
Cyprus.
So which state has...
Cyprus.
So Cyprus, okay. So Cyprus has said that it might use it. But it's the only case. I mean, you don't see Italy, Portugal, Spain that have that. And even because, moreover, you have the ECB. And I think the use that's going to be made of it is limited. On the new program, in fact, there is conditionality that is foreseen, because it's associated, the new generation program, the funds will be paid for to finance national reforms that will be part of the European semester monitoring. And it's also foreseen that the sums are to be disbursed progressively, and in light of the extent to which the member state in question reaches the targets that are defined in those policy reforms. So in fact, the new generation program seems to be the reforms contracts that had been suggested several years ago by people like myself, and most notably in the council by Mario Monti, in the famous Mario Monti proposal several years ago. It seems to be something like to pay for contracts for reforms. Now, why do I think that now that in respect, it's also a little bit what you have with EU structural funds. Any member state that benefits from the EU structural funds has to negotiate a partnership agreement with the European Union. It's called a partnership agreement that determines the conditions under which that member state is going to make use of the funds. So the institutions that are going to manage, the rules that are under which they're going to manage, and the policy areas and the policy objectives according to which those funds might be used. So now the different thing is that it's no longer policy objectives, it will be specific policy reforms that will be funded through this money. Now, I'm still very skeptical of these forms of conditionality, because I think, as Christine Joerges just said, the track record of the European Union with respect to conditionality is not very good. It's not very good with respect to many aspects of the EU structural funds, and is not very good with respect to what happened in terms of fiscal consolidation, and because it focused on measures on budget targets and not on structural reforms of the countries. So it didn't really promote structural reforms. In fact, having been the experience of being in government, sometimes the way the rules were being used and conditionality was being imposed would require us to make a trade-off in having shorter-term, better budget consolidation results in exchange for more structural measures, for example, on the capacitation and quality of the public administration, that in my view will be much more necessary and much more effective, including at the budget level on the medium long term, but that because they will not produce the kind of short-term effects that that other budget consolidation measures will produce, could not be adopted. Let me give you an example. For example, in the case of Portugal, the public administration problem was not only a problem of the level of expenditure with the public administration, but it is that and with the wage bill of the public administration, but it is also with the structure of that public administration. In fact, if you compare, and it's the case with Portugal and other member states, if you compare civil servants payment in Portugal, those on the lower levels, on the lower echelons, are better paid than the same people that do similar tasks, similar jobs in the private sector. And as you go along, the higher you get on the public administration, the worse paid they are with respect to the private sector. So you have an inverted pyramid, basically. So this tells us that if you wanted a good quality public administration, you had to be selective, and you had to create incentives also to attract the best people. But if you are required to consolidate budgeting on the short term, and that means that you need to take measures that are very blind, both because most of the public servants are on the lower levels, and because it's not socially acceptable if you're cutting the wages of people by 10%, that at the same time you're telling them, oh, we're cutting the wages of 10% of those that are paid less in the public administration, but we're going to increase those that are at the top levels of the public administration because they are badly paid with respect to the private market, and we need to have more quality people there. It's simply not feasible socially to do that without basically starting a revolution in the country when you're doing an austerity measures. And that's the kind of distorted incentives that conditionality that is based on short-term budget consolidation promotes. And I think that, as I said, actually to some people of the Troika and European institutions at that time, that meant that a good part of the results that were being achieved in terms of fiscal consolidation will not be sustained in the medium long term. And I think they knew, but at the same time, they wanted to achieve results that were politically acceptable on the states that were funding the programs. So that's the reason. So this leads me to what I think it's the really conditionality that might work. It's conditionality that focus on systemic changes in terms of the quality of institutions. So let me give you an example that relates that with other form of conditionality that's being discussed, and it's a proposal that I made. I did it in a lecture in Brussels, and I'm going to do it in a short paper because it links with the rule of law concern and the rule of law conditionality. I think it will be a huge mistake to have conditionality that basically makes disbursement of funds, of EU funds, dependent on compliance with the rule of law standards that will be very hard to define in terms of metrics, that likely will be bypassed easily by some member states. It's enough to say that almost any measure that Hungary has taken, Hungary always gets an example of another member state having a similar measure. So when they separated the administrative jurisdictions and the administrative courts, we know why they did it. They did it because they want to put judges of their of the political that are politically trusted by the current government in the new administrative jurisdictions. But they say that they are simply endorsing the jurisdictional nature of several European member states that in fact do have a different administrative jurisdiction than common jurisdictions. So how are you going to say to Hungary that you're going to suspend EU funds because they are embracing a reform that fits what exists in other member states? How do you say that they are not interfering with the public prosecution or judges on them appointed, and then you have countries like Spain that have the tradition, like the current government of Spain appointed the Minister of Justice directly to be the Attorney General. So this will get the European Union in a mess because in terms of these kinds of measures. So what do I think that the European Union can do? The European Union can guarantee that at least the institutions that will be involved in the management of EU funds in those countries are genuinely independent from the political power. So that they, for example, so that the EU funds will not be captured by the political power. And in doing that, it's creating and reinforcing checks and balances within those member states, because it's reinforcing the independent institutions. And it should do that, in my view, with other administrative agencies. Now, this requires that the European Union will have a mechanism, for example, that the agencies that at the member states level are going to manage these funds need to have independent people. How? It's not enough, in my view, what happens with for example, with the control on the European central banks. It will be a step forward, but it's not enough. And I won't get into that. Even Portugal is going to be another case of how the ECB does not properly monitor the independence of the central bankers. But anyway, because in the case of Portugal, we now know that the current Minister of Finances and former President of the Eurogroup very likely will immediately go to become the next governor of the central bank in Portugal. So how can you say that you guarantee the independence of the central bank when the Minister of Finances basically appointed himself to be the governor of the new governor of the central bank? And moreover, he's going to have to decide on a variety of issues of assistance on financial banks. And it seems clear to me that the ECB will not intervene. So what you need, I would suggest that we need a system for this, and we could start with the EU funds, similar to what we have for the European Court of Justice, that has worked well. Many people thought that it would not work, and has worked well. That is an independent committee at EU level, to which the member states will have to submit the people that they appoint to these management bodies for the EU funds, that will manage the EU funds. And this independent committee at EU level will guarantee that these people really are independent, fit the criteria of independence that are necessary. In the same way that happens with the European Court of Justice and the General Court, when, as you know, member states nominate the candidates, but they have to pass a test of independence that is scrutinized by an independent committee, and that has been very effective. There's many cases, some of them are not even publicly known, where this committee has vetoed appointments made by the states that were strongly political. So I think that we should use that thing, and that the conditionality should be mostly focused on reinforcing the quality of the institutions at the level of the member states, and that the best instrument to do it is by starting with the institutions that are going to manage the EU funds. You had also made the first question, and I don't remember anymore what it was, but this one was already too long.
Yes, thank you. But in a way, you are.
Do you allow a short comment on that? A very short comment on Miguel. Miguel, this was perfectly Hayekian in a very positive sense. Hayek has this great insight into, indeed, the integrity of institutions. And the other part of your intervention was Hayek also wrote about the pretense of knowledge. Administrators, governments who pretend to know how they can resolve the problems, and they always find out it doesn't work. This was the first part of you. And the response of Hayek to that was indeed these kind of institutions. I'm not saying that Hayek is an idiot. It's an extremely insightful person. Okay.
So, Dr. Borrelli, we have understood that nobody really loves conditionality as it has been developed in the past. And the question to you is whether or not in the new Commission instrument, there will be tools to have a, let's say, smart conditionality similar to what Miguel proposes, for instance, or whether it is the old story, old Greek-style conditionality, and that's it.
Well, I will be very brief on this point. I would just like to, agree with what Augustin was saying concerning the legal aspects of application and possible removal of conditionalities in the long term. So I will not add anything to that. The conditionality removal as it is now is, of course, a temporary measure. And as far as concerning particularly the country that I know best, which is Italy, where I am currently working, the concept of conditionality has been linked in the public debate with the ESM, with the European Stability Mechanism. And it is also known that many countries, as Miguel was mentioning, still continue to have very strong skepticism and suspicion vis-a-vis ESM, even without conditionality, or even with the only conditionality which is linked to the health sector in which the loans can be utilized. That being said, I would not be so sure that all countries will renounce to this great possibility in terms of source of funding. And probably the next big debate in the Italian parliament will be about that, because there are many political forces within the majority and even outside the majority that would like to benefit from this amount of money which is available now, and not like the next generation EU will only be available in its biggest part only in the next years. So I'm not sure that Italy will renounce to it. It will be the core debate of the next few months. Conditionalities, in any case, I agree with Miguel. I'm afraid, or I'm glad, are there to stay in the long term, because finally, conditionality have always applied to all modalities of aid from the Commission. We have seen the Next Generation EU instrument, which is linked to a reform plan that the country has to present beforehand in the framework of the European semester, and that is going to be constantly monitored to verify the achievement of the different targets across the time. So there is conditionality even there. Conditionality applies to the SURE mechanism, the one for the unemployment, because it can only be used to help people who are at the moment unemployed. So in a way, to make it short, I think conditionality are a necessary tool to ensure that funds, whether they are grants or loans, are used in the most effective way for the country and for Europe. But of course, it must be the result of a joint effort from both the institution and the member states that have to agree on the modalities to monitor them and to apply to them.
Thank you. And last round, last question, we arrive at the legal core of our discussion, which has to do with the German Constitutional Court and this challenge to the ECB, to the ECJ, to the EU law supremacy. The ruling is already too known to be presented. The political message maybe is clear. The risks are quite clear. They become a sort of Pandora box of other kind of constitutional court following the example, but the legal tool maybe that the court has made use of are far less clear. I know that many of you have already written on that ruling. Maybe your position are somehow different. And I would start this round precisely with Dr. Borrelli in order to ask whether or not this idea of bringing an infringement procedure against Germany has some room of maneuver in the Commission view or not.
This is $1 million question, and I'm really not in a position to give an answer. I think that in any case, this pronouncement from the German Constitutional Court gave the possibility to many very high-level political actors to give a feedback in terms of political stances that they took. And it was clearly stated that the supremacy of the European law stays there. And in that sense, we have seen that this recommendation from the Constitutional Court, this judgment, has not been followed. We know also that the judges of the Karlsruhe Court, with their judgment of the 5th of May, have put into discussion a system of European monetary policy of the last decade. So they have made really a very, also very brave move. But their judgment is also true, does not reflect, I think, the views of the globality of the German economic and financial sectors. The court has in fact based its pronouncement on the recommendations of a limited number of experts from Bundesbank, from academia, from the sectors of banking and assurances, according to whom the ECB, the European Central Bank quantitative easing with ample purchase of national bonds may damage Germany, lowering their interest rates. But in recent times, many other German economists have subscribed pleas in favor of more solidarity of Germany in Europe. And probably, I think that also Chancellor Merkel listened to these pleas, given that on the 18th of May, only a few weeks after this judgment, she endorsed with Macron a proposal for recovery fund worth 500 billion euros, which eventually the European Commission broadened to a more sophisticated package of 750 billions. So in practice, the thesis is prevailing that Germany not only is not harmed by the pandemic emergency purchase program, the PEPP, but it can benefit from it as it fosters growth in Europe, which is a situation that stimulates and stabilizes the Eurozone economy, so to the best advantage also of Germany itself. So I would say that at the end of the day, it's not probably so important if there will be an infringement procedure from the Commission, but it is important that this recommendation has not been taken into consideration, not by Merkel and not even by the European Central Bank, that has now only a few days ago relaunched the PEPP, adding 600 billion euros to the original 750 euro.
Thank you. So you didn't want to tell us whether there will be an infringement or not. We'll see. And Christian, this floor is yours. Maybe you can explain to us the alternative clause of the German constitution.
I told you at the beginning I would save some time, and this will be a little longer now.
Yes.
The principle of supremacy is my darling principle. I must say I have never understood it. I cannot understand how it became such a holy cow of European law scholarship. It is, in my view, not worth to be this flagship. Why? Because the only rationality you can find for it is technocratic. You promote uniformity in Europe with the help of supremacy, because supremacy ensures that everything is treated according to the same principle and rules everywhere. Now, is this such a good thing? Is diversity then such a bad thing? I will really plead no. It is a mistake to say that the principle of supremacy is a sound economic and social principle. But let me make a little historical circle. The principle has been, and this is unfortunately something nobody takes seriously, but I think these historical considerations or historical consciousness is quite illuminating. The principle has been invented when Germany has occupied the rest of Europe, in particular Belgium. It has been invented by a later very famous scholar of European law, Hans-Peter Ibsen, who explained to these, who was then the commissioner of the Free University of Brussels, and there were these debates between German military law and the Belgian constitutional law, and he invented supremacy of German military law, of course. Now, this is a thing which is, of course, not directly, but it is the idea that an administrative rationality, technocratic rationality, in the worst case, military rationality, is a higher law than constitutional law. This historical side understanding, I would explain my reserves more precisely with the German Constitutional Court. And I don't depart from this last one of 5th May, but an older one, the Lisbon holding, and this was 1916, I think, yes. Now, in that case, we have already indicating the German court was his reserves against European law, and especially against European monetary policy, the supremacy. And the interesting thing is that in that case, the opposition against the adoption of European rule was not only opposed by Mr. Gauweiler and his friends, but it was also criticized by the left in Germany, especially the Linke. The German Bundestag party of the Linke was totally on the side of the critiques of the Lisbon Treaty. Why was this so? Now, in order to understand this, I have to go into the German constitution, which is not as uniform as everybody seems to believe. We have two traditions in Germany. One is, so to speak, to make it brief, the ordo-liberal tradition. Germany has an economic constitution, and this economic constitution ensures economic rationality and competition and all that. And the other one, however, is the social democratic state, the social constitution, the labor constitution, which is also protected by the constitution in the eternity clause.
Excuse me, Christian. Christian, can you
closer to the micro?
A little bit louder, yes.
Yeah. The important thing is that these two traditions have always been fighting against each other, and the idea of the social constitution or the labor constitution was one which was insisting that democracy should not be limited to, say, the ordering of the economy according to competitive law principles, but to the democratization of the economy itself. Now, this is why the Linke opposed or was siding with Gauweiler in that constellation, but the point of the Linke was one directed, and Miguel will know that, against especially Laval and Wicking. And because they said these decisions are irreconcilable with the German constitutional eternity clause, which respects the social democratic state. And this is, there are a couple of principles which were affected, especially, of course, the power of the labor trade unions and this kind of stuff. Now, the Linke tried to insert this into the proceedings, and there is a tradition in German jurisprudence that the courts have to respond to the things that the Linke, or in this case, the Linke, that the parties came up, and they did that. And the man who did this was representing the Linke from the Bundestag. This man is Professor Fiesan, and he had been formerly an assistant in Bremen, a research assistant. So I could easily contact him and say, look at that and bring that up. And he did that, actually. And the court actually responded. And how did the court respond? And that is interesting. I think this leads to our problem now. The court said, yes, that is true. There is a problem here. We have, on the one hand, not only to defend the autonomy of the German Bundestag in its budgetary policies, and the Staatswillensbildung, the authority of the state, we also have to consider the social clause. Now, but then as I said, the European Union, this is the text of the treaty, is a social market economy. We always praise ourselves of being a social democracy. So they went through a couple of provisions we have, and this highly competitive social market economy, which is in the treaty with all its promises, is proving that the social clause, the social eternity clause of the German constitution cannot be. Now, my point here is that there is an imbalance in the jurisprudence of the court. On the one hand, They are very rigid when it comes to budgetary autonomy of the Bundestag, and they're very relaxed when it comes to the social stuff. And there they, so to speak, give way to one tradition in Germany and forget about the other. Now, what the point I want to make, however, is that the difficulty of doing something in that field is intimately linked to the diversity of Europe, the social and economic diversity. The institutions which constitute the famous German model are particular, and they cannot be simply exported to other nations. Take a thing like co-determination, take the educational systems in a couple of institutions which form the core of the German model in the German social model. They cannot be exported, and this is why, if you want to save them, and there the German court has understood, if we insist, then we will have to depart from the common European trend. The only way out of that is to recognize the autonomy of national labor constitutions. And this is why I would say the supremacy principle is really a dangerous principle, because it assumes that we can treat all these things in Europe alike. I would say the only way to preserve these labor constitutions is to respect national idiosyncrasies, particularities, and to seek for mutual tolerance. By the way, one thing which we have accepted as a principle in European constitutional law. Now, if this is so, then I would say the way out, and I've mentioned this before, out of this dilemma is not to say, let us wait until everybody accepts German Mitbestimmung, or let us wait until everybody has adopted the same economic culture. No, let us see to it that we can live with a diversity of economic cultures and labor constitutions. Now, this was all what I preached since decades on the conflict of laws vision of European integration. And to my delight, I have read an opinion by an advocate general, a Spanish one. I don't know whether he is well known in Spain, but the man is great. Advocate General Sanchez Orduna. Augustin will better know how to pronounce him, but he has delivered his opinion on the Posted Workers Directive, a very important piece for every labor lawyer, Antonio, as you know. And what did he say? He said the Posted Workers Directive is an example of modern conflicts law, modern private international law. And why is that so? Because this directive seeks to compromise the ambitions of, say, the Eastern Europeans, the accession states, to enter the Western markets through social dumping or through low wages. And on the one hand, the defense of these standards of Western Europe. And the Advocate General approves the new revision of this directive and rejects the complaints of Hungary and Poland, both of them opposing the new directive. And he does it in the name of diversity of the labor constitutions in Europe. And this I find very remarkable. Unfortunately, I have not found the English translation of the opinion. It's very long, very complex, and very interesting. But in basically what I see as a glimpse of very, not more than a glimpse, it's a real signal of hope that suddenly some official institution understands that we cannot impose on a social and economic system, the social and economic system's uniformity in the name of supremacy of what have you. It is not possible. Now, the last resort I have is, of course, a bit political economy or economic sociology. We all know that economies, markets are socially embedded. And if they are socially embedded, they are political institutions. They will not be uniform, and it will be hopeless to impose on them uniformity from above. They will strive with different mechanisms, Now, the vision again of this opinion is don't try to harmonize, to adopt a uniform labor constitution all over Europe or a uniform socio-economic model, but try to live with a diversity. And this is also my answer to supremacy. If supremacy is understood as a means of imposing on these members of the European Union a discipline of coordination and cooperation, then it is fine. As when it turns over into a command and control instrument which imposes a uniform model on the whole of Europe, it will not be successful. And the opposition against Europe is, I think, partly generated by these kind of experiences people have, that they lose what they feel is important, and it is not simply the political right. It is really the social democratic tradition, especially in Germany, which is not happy about that. This is it.
Thank you, Christian, for having tell us the German history of this ruling. You have placed the conflict between the two courts in a legal political perspective. But what I would ask Augustin to tell us is, on the contrary, what he has already written upon with some colleagues, the past blog, an economic political perspective of this ruling. You can say something about that.
I will make three very short points. The first, I think, is that Euro lawyers, so to speak, have deeply misunderstood the conflict. The first reason, I think it's very clear, has to do with the whole discussion about supremacy or the infringement procedure. On the one hand, I have the feeling that we have got final confirmation that so-called pluralist theories of European law, which were once so fashionable, were in some cases instrumental ways of clothing a bid to supremacy, which ignore and keeps on ignoring that constitutional supremacy cannot be established on functional grounds, but only on democratic force and legitimacy. To be very brutal, to assume that Luxembourg has stronger democratic credentials than Karlsruhe is to deceive oneself. To claim that it's a brilliant idea to start infringement procedures against Germany is absurd. Second point, the two courts have clung to different parts of the Eurozone wreckage without realizing that the European Constitution of Money has been basically honored in the breach since 2007 because it's impossible to comply with it. It is deeply intriguing that both courts keep on accepting as normatively and factually true that the ECB is independent. No, it is not. And to conclude that there has been no actual monetary financing of debts. Yes, there has been. Given the facts that the German court considers as proven, what is surprising is not the ruling, but that it finds, so in the ruling it finds problematic the proportionality assessment of quantitative easing undertaken by the ECJ, but on the contrary, it has sufficient doubts as to exclude that the acquisition of 20% of the public debt of the Eurozone entails monetary financing. Sooner or later, that debt will be written down one way or the other, because all alternatives would be even worse. Third point, the German Constitutional Court has failed strategically and in the process has proven the unfamiliarity of German institutions with the use of soft power of the hegemon. Lack of wisdom is revealed not only in the choice of words to characterize the ruling of the ECJ in vice, even if the substantive criticism is completely correct, but also in the lack of regard for the limits of a constitutional court. Lube Wolf's dissenting opinion in the preliminary reading in Gauweiler seems to have been fully vindicated. So, what is the core of the decision? The core of the decision is not supremacy, The court of the decision in 2020, May 2020, is about what do we do with the Eurozone. And what do we do with the Eurozone is something that is not being addressed by most of the discussion regarding the ruling.
Thank you, Augustin. And to conclude with Miguel, yes, your final point was precisely the one I would have liked to submit, Miguel. And it is the following. There is in the many writings and comments on this ruling, there is a line of thought saying, well, at the end, someone has finally said what nobody had the courage to say, that we cannot go on in this way. It's like the baby is the emperor new clothes fairy tale. Someone at the end said, Europe cannot go on with these ambiguities and hypocrisy and distinction between monetary policy and economic policy. And finally, German Constitutional Court has put feet on the table. Would you agree with this line of comments, or see only problems and dangers?
I think that it is a mistake to treat the European Union as if it is as a kind of democratic reason that is unified and not the project of a deliberation between different political communities. You always, when you hear criticisms of the European Union, you always say, well, someone finally says that something needs to be done. But the problem is that what people want to be done needs to be done by the European Union in Italy or in Spain is different from what people in the Netherlands or in Germany think needs to be done by the European Union. So that's not a very productive conversation to be had. It's very fine. We might feel fully satisfied, tweeting about it, writing posts in Facebook, or in our cases, long academic articles on how the European Union is failing all of us and cannot do anything. But I always find that highly unsatisfactory because it's not constructive at all. And if you want to be constructive, then you have to engage with the difficulties of trying to produce a form of public reason when you are engaging different political communities at the same time. And that's what I think that everybody needs to understand, including constitutional courts. And that's what I think the German Constitutional Court didn't understand. And I wanted to, there are many things I've commented on the decision already. I think the decision is inconsistent even with its own standards of the German Constitutional Court in any well. That sets a very high threshold to declare that the European Court of Justice has not fulfilled its function, and then to go on and say that that is the case because of the application of proportionality on its strict form of proportionality. It's not appropriateness, it's not necessity, it's the cost and benefit balances in an area where, moreover, normally courts are extremely differential either to the political system or to independent agencies as a European Central Bank is. I find it puzzling, if not for specific conditions that, in my view, have led a majority in the German Constitutional Court to decide this way, because they wanted to send a sign to the European Court of Justice, and they chose perhaps the wrong case to do it. But I wanted to check on the extent to which courts also need to do that, and actually to disagree with Augustin when he makes a very sweeping judgment that the European Court of Justice does not have stronger democratic credentials than the German Constitutional Court. And we have to be, of course, and I understand that what he means by democratic credentials talking by courts is different than what he means by democratic credentials talking on the part of a political system. But when courts second guess and assess the validity of a decision of an institution, there's an element that where those democratic credentials is because they see a malfunction in that institution, for example, a problem in representing interests, that authorizes those courts to step in and assess, for example, proportionality. The problem in this case is that, and it's visible in the case, in the way proportionality is assessed. If you look at how the German Constitutional Court basically highlights a series of effects that it considers to be economic effects and negative economic effects, or potential negative economic effects, such as the creation of real estate bubbles, or the losses in terms of savings in banks' accounts that result from this ECB policy. All the effects, the economic effects that are taken into account by the German Constitutional Court are economic effects that basically reflect the debate on the ECB policy that takes place in Germany. And that is legitimate. In Germany, you have lots of pension funds, and people save money, and a lot of them, and they are losing money because the ECB policy means that the rates on their savings in the banks and for their pension funds are lower than otherwise they will be. But those are only a set of effects that the ECB policy takes. Even if one would assume that the German Constitutional Court was right, that one should subject the ECB policy to this kind of assessment, it is very revealing that in the costs and benefits analysis that is done by the German Constitutional Court, only the economic costs that are normally discussed in Germany are taken into account. There's no mention, for example, of other benefits that result from the measure that are taking place in other member states. And that is a function of the judicial proceedings in Germany itself. Only German pension funds had standing and were able to participate in the case. By definition, the interests that were heard in the judicial case in Germany were German interests. But that only highlights that it is extremely problematic for a constitutional court of one member state to actually assess the legality of an act of the European Union that needs to take into account its effects, including the costs and benefits, in 27 member states, and not only in that member state. The national nature of the proceedings before a national court, particularly, by the way, when you're assessing the legality of a national, of a EU act, even if you say that you are assessing its application in Germany, the fact that's what they're doing, and that's the nature of the reasoning that they are employing, it's very problematic to be done by national judicial proceedings that do not reflect and are not in the best position. So I would say that the European Court of Justice actually has to the assessment of the costs and benefits of a EU act in the 27 member states, it has stronger democratic credentials than the German Constitutional Court. This is all relative, and that's what counts, because a EU act of that type has externalities in all member states, involve interests in all member states. Is the German Constitutional Court in a better position in terms of democratic credentials to assess those interests that are affected in all the 27 member states? It is not, in my view. So, and that's precisely the point. And if we consider that is not so, then we might as well basically give up on the idea of having a EU jurisdiction at all. It's a totally different organization of the legal order. Perhaps is a legitimate one. Perhaps there are arguments to say it is, but it's something substantially different than what we have today. And what I think is that if then you need to present an alternative and say what that alternative will be, and why is that not only an ideally in abstract better alternative, but why is that a more feasible, better alternative than the current alternative?
May I just add that you should, Miguel, and Augustin has pointed to this dissenting opinion by Lieberwolf, and Lieberwolf said this a complaint was inadmissible because no court in the world is able or should be entitled to give a judgment on the future of the euro. It is a problem of such magnitude that no court should do that. She says it with particular respect to the external effects of a German decision would have on the rest of Europe, not only on German pension funds, on mine, for instance, and so on, not important. What is really important is the question, is this still a thing which we can leave to the courts, be it the German court, be it the European court? And when we started the debate or our discussion, I've pointed to this diagonal conflict between monetary policy and economic policy. And my point was, this is irresolvable by law. No court in law can give a legal judgment. I call this the undecidability doctrine, which is a doctrine very rarely discussed because these cases are so rare, but it is one which one has to take seriously. Where are the limits of juridification? And here we have reached them, I would say. And to say we don't decide this in a court would mean we give it back to the political process. And there it belongs to. I'm not fantasizing about the quality of this political process, but to say there is a court who can tell me what the right economic constitution of Europe is, and then to say, aha, this is all technical stuff, and it's a thing which is not policy at all. It is expertise, and the expertise is with the ECB, and this kind of reasoning is unacceptable. Okay, last.
Thank you. I guess that we could open up our 10 minutes, no more than 10 minutes, debate by Marzia, because I think she has a question very closely related.
Actually, I would have a question, and I was wondering if there is a way of reconciling different perspectives. What do you think about the proposal made by Joseph Weiler and Daniel Sarmento of establishing a new appeal jurisdiction? Perhaps you have read about it.
Yeah, I've seen
in the Court of Justice, a mixed grand chamber, which should be composed by members of the Court of Justice and members of national constitutional courts, where there is a problem of drawing a jurisdictional line between the member states and their European competences. Do you think this could be a
Thank you for the question. We have just heard Lou Wolf, and she said after her dissent, which was not at all to the liking of her colleagues in the Second Senate, she has written a couple of articles, and she proposes that this kind of judicial conflict should be transformed into sort of judicial diplomacy. Now, Joseph Weiler has written long years ago on the WTO proceedings, and he said the value of diplomacy and so on. So there is a feeling for, here we are at the limits of the law. What I always cite a very old German constitution is, das Recht hört hier auf, the law runs out here. This is a question of such dimensions that we cannot say this is a judicial, legal question. And Weiler, in a way, accept this kind of observation. He says this is something we compose a forum where this can be debated, but we are also, I think, sure they have realized that this is no longer a legally structured decision predetermined by some legal text, but that it is hopefully the outcome of some deliberation which will do some justice to all the parties involved. Then I can accept it. I don't know whether Joseph Weiler and his colleague would agree, but in principle, to replace handing down a decision from some, well, in jail or somewhere, it is rested, but it can no longer be a legal decision in a strict sense. So,
okay. Thank you. I know Miguel has to leave because he has other engagement, but I have Piera Loy has asked to intervene. Please, Piera.
Yes, can you hear me?
Yes, perfect.
Maybe now you can see me, I don't know.
Yes. Yeah.
Okay, so good morning, good afternoon to everybody. Well, I know it's very late, so I will say very briefly something about the question of how the European politics have changed in some ways. It should change in some ways its priorities, because if we think that in recent times we have faced different kinds of risks. The financial risk in 2008, the migration risk still ongoing, health risk with the COVID-19, and the climate risks on the horizon. So I think that we should maybe change the way of conceiving any economic or even social policy at European level. First of all, as labor lawyers, we are always concerned about the fact that these risks have affected unequally. They had an asymmetric impact on member states and inside member states on different categories, with people and workers bearing more costs than others. And so what is at stake is the capacity of the European Union of finding different insurance mechanisms to face these different risks, making recourse, of course, to legal and economic resources. And this should be done, of course, using the solidarity principle. And solidarity principle, which is, as Durkheim said, at European level, it could be described as an organic model of solidarity. But what we are facing today, in my opinion, is that we are facing a kind of difficulty of reconciling the solidarity principle with other general principle of the European Union legal order, like the proportionality principle. Of course, the German Constitutional Court ruling of 5th of May 2020 used this legal principle, this legal tool for, and the idea that the European Central Bank did not balance the economic policy effects and the advantages in the area of monetary policy. But I think that now is the time to admit that unusual forms of solidarity are emerging, and we should use the proportionality principle. We should not use the proportionality principle to undermine this solidarity principle. So we have to go out from this clashing. In my opinion, the proportionality principle in that case has been used by the German Constitutional Court, also by the European Court of Justice in other occasions like Viking and Laval, not in the correct way, because we have to yes, as Miguel said, we have to use a wide range of issues to see if the compression of fundamental rights has been menaced or not. And in this case, if the menace came from the risk, the economic risk. That's it. Thank you.
Thank you, Piera. I would like to keep you on the screen, but we have one last intervention by Luca Ratti. Luca, please.
Yes. Can you hear me?
Brief.
Can you hear me?
Yes, but we don't see you.
Oh, it doesn't matter. It's a remark and.
Now we can't hear.
Now
yes. Okay,
yes.
I do. Because we all observed that the more the crisis went on, the less the EU and its institutions became popular. And believe me, even here in Luxembourg, it seems to me that the anti-EU arguments got teeth. Now, the question is about the latest initiatives by the European Commission that seem to me very much powerful. In particular, I have in mind the very sure regulation is the first one. A second one is the relaunch of the second round of consultation on an EU minimum wage. But even a third measure seems likely to come, and it concerns the German presidency plan to plea for an EU minimum income scheme. So how would you see all this will impact on the anti-European sentiments on the one hand, and on the other hand, on the diversity of what you call the labor constitutions in Europe?
Thank you. I don't know. Thank you, Luca. Whether someone of the panelists want to reply or not, the intervention. Otherwise, I would just like to thank you. And to all of you that are already online, I just would like to communicate future initiative of the labor law community. Just 1 minute to say that there is already one seminar on pandemic, post-pandemic, and work. And there will be a call which will be circulated in the next few days. And there is already a deadline for presenting papers, which is end of October 2020. And then there is another seminar on working women or women at work, which is not yet precisely calendarized, but should be fall winter of 2020. So keep in touch and stay informed about our next initiative. Thank you very much to all of you. Have a good day.
Ciao, ciao.
Bye.
Basta.
Bye. Thank you.
Grazie a tutti.
Grazie.